Time matters for trademarks. Whether you're launching a new brand or protecting an existing one, understanding the critical dates and deadlines in trademark law can make the difference between securing your rights and losing them. Keeping track of trademark timing is essential for protecting your brand and staying ahead of the competition. Leppard said it's too late for love, but let's look at whether it's too late for your trademarks. Does it matter when you apply to register a trademark? Absolutely. Timing can determine whether you get exclusive rights or end up in a legal battle. Here's why. Unlike patents, the US operates on a first-to-use system for trademarks, meaning the first business to use a mark in commerce generally has superior rights over a later filer. Filing an application with the US Patent and Trademark Office, or USPTO, can strengthen those rights. This could become complicated if you filed first, but someone else used it first. So that's a situation you should definitely discuss with a seasoned trademark attorney. The moment you file a trademark application, you establish a priority date. If someone applies for a similar mark after you, your earlier filing date could give you the upper hand. Again, if they used it before you did, though, consult a trademark attorney. Not ready to launch yet? If no one else is using the mark for identical or similar goods or services, you can file based on intent to use and reserve your spot in line with that priority date as long as you follow through with use in commerce later. How long do trademark rights last? Trademarks can last indefinitely if you maintain them properly. Here's the breakdown. For common law trademarks, which are unregistered marks, rights begin as soon as you use the mark in commerce. Protection, though, is limited to the geographic areas where you use the mark, and you don't get the benefits of federal registration. For federally registered trademarks registered with USPTO, the initial registration lasts for 10 years, but it's not automatic. You have to renew it. Between years 5 and 6 of the registration, you must file a declaration of use, or a Section 8, to confirm you're still using the mark. You must show examples of the mark still being in use. After 10 years, you must renew. Sections 8 and 9 are what you file then, to keep your registration alive. With each renewal, you must show examples of the mark still being in use. As long as you continue using it and renewing it, a registered trademark never expires. It can last forever. Here are the key trademark dates to remember. The first use date, which is the date you first use your mark in commerce. For state registration dates, rules vary from state to state, so I won't go into state filing and renewal dates here, but if you are pursuing state registration, you need to know what those are for that state. The application filing date is the date your trademark application is received by the USPTO and it becomes your priority date. Next is the publication date. If your application is approved, your mark is published by the USPTO for opposition, meaning others have 30 days to challenge your application. Then there's the registration date. If no opposition arises, or if one does and you overcome it, your mark registers with the USPTO on the registration date, giving you nationwide protection. Finally, there are maintenance deadlines. You must file maintenance documents with the USPTO between years 5 and 6, at year 10, and every 10 years thereafter. A strong trademark can be one of your business's most valuable assets, but only if you protect it. Filing early, maintaining your registration, and tracking key deadlines will help ensure your brand remains exclusively yours. If you're unsure about a timing, a trademark attorney can help you navigate the process. Do you have trademark questions, especially about timing? Please drop them in the comments.